I'd like to call to order the Planning Commission meeting for April 22nd at 7 o'clock. Will we please all rise for the Pledge of Allegiance? Thank you. Yeah, I know they keep moving the flag. See if we can find it. First thing I'd like to do is address the approval of the minutes from February 25th, 2021. Can I hear a motion, please?
Second.
All in favor?
Aye.
Consider minutes approved. Now we're going to get into the public hearings for tonight's meeting. Okay. Ms. Zek, will you go through the? Oh, I'm sorry. I should do introductions first. I apologize to all. Okay. I'd like to introduce the members of this board. Mr. Bob Schwartz from Bowling Green. Dr. Carol Horton from Port Royal. Chris L. Minor from Mattaponi. Gary Dudley from Western Carolina. And I'm George Weaver from Madison. In staff, we have Mike Fincher, who is Director of Planning. Chris McKenzie, who's our county attorney, and he's watching right over there, so he's watching over us very carefully. Craig Pennington, where are you, Craig? Oh, there he is. He's hiding over there. Craig Pennington, he's a planner. And Lisa Zek is Administrative Assistant at Planning Tech. Lisa, can you read us into the public hearings?
Yes, thank you, Mr. Chairman,
Thank you.
members of the Commission. The purpose of a public hearing is for the Caroline County Planning Commission to listen carefully to the verbal expression of position and opinion from the citizens of Caroline County. Public hearings are not question and answer sessions or debates, and all statements should be addressed to the chair. When members of the public offer comment, they need to clearly state their name and address prior to making their comments. Applicants or representatives of the applicant will be allowed 15 minutes to introduce information regarding the matter advertised for public hearing. All comments are to be pertinent to the issue being considered. Persons speaking at public hearings are respectfully requested to keep comments brief, not to exceed 3 minutes, and to address only those issues pertinent to the matters advertised. After the public hearing has been closed, the applicant or his representative will be allowed 10 minutes to address any issues identified by the public.
Thank you. So the first public hearing that we're going to have this evening is RZ 02-2021, Quality Land Group, LLC, owner and applicant. Would the applicant like to speak at this time? Excuse me, sir? I'll take a staff report. That'd be good.
Thank you, Mr. Chairman. Applicants requesting approval of rezoning of tax map parcel 85-A-52A from rural preservation to M1 industrial for a contractor equipment storage and sales facility and office. The applicant currently utilizes the home office to operate Quality Grounds as a landscaping business in Caroline County. The parcel noted on this application currently houses a storage facility for the equipment used by Quality Grounds. The owner would like to move his entire operation to this location. In order to operate as a contractor equipment storage and sales facility, the property must be rezoned to M1. The RP zoning district allows for this use as a special exception if the owner of the business lives on the property. The applicant does not reside at this location, therefore rezoning to M1 would allow for this use. The site currently has 5 barn-type structures located on the property to house equipment. Further expansion of the site is encumbered by a resource protection area on most of the parcel. There is room towards the southeast of the property where another structure could be located, but none is planned at this time. The Virginia Department of Health commented the drain field should be inspected to determine if it's adequate for the number of employees, and the applicant should contact the Office of Drinking Water to determine if the business falls under their regulatory authority. Comments have not been received from VDOT at the time of this writing, but the parcel currently has an approved VDOT entrance to the facility. Technical review comments were not requested from other departments' agencies because minimal changes are expected to the use of the site should the rezoning be approved. The comprehensive plan designates this property as being rural preservation and outside of a growth area. M1 zoning for this parcel is not consistent with the Caroline Comprehensive Plan. However, this use is allowed in a RP zoning district as a special exception if the owner lives on the property. While contractor equipment storage and sales facility is compatible with the RP zoning district, many M1 uses permitted by right or special exception may not be appropriate for this site and/or area. A number of uses may be encumbered by the resource protection area, which covers most of the parcel. No proffers have been submitted with this rezoning. And this week and last week, we received 3 to 4 calls from the adjacent property owners that received a letter regarding this rezoning. All 3 or 4 of those calls, I'm pretty sure it was 3, but all 3 of those calls were okay with the rezoning, didn't have any comments, and left it at that.
I have a question for staff, if I may.
Yes, sir.
If not out of order.
No, you're not.
You said the applicant must live on the property.
Yeah. So the RP zoning district allows for this use if the applicant lives on the property. And so if he was living there, he could do this as a special exception instead of a rezoning. He does not reside at this property or plan to reside at this property. So therefore it has to go to industrial for the same use that is allowed in an RP district if he lived there.
So if he lived on the property, this would not be a huge issue.
Right. It wouldn't be a rezoning. It would just be a special exception request.
Okay, thank you. Question from the board to staff?
Mr. Chairman, if I may. Mr. Pennington, this used to be the old Luck Stone and Gravel property, I believe. Is that correct?
Yes, that's correct.
When Luck Stone and Gravel went in and began operation there, was this zoned rural preservation at the time?
At the time, yes, they did not do a rezoning. They were there prior to those requirements. And so the property has always been rural preservation, even while they were operating.
I understand. I don't know if Mr. Parker is here tonight or anyone on his behalf, but I think I understand the business logic of wanting to consolidate and put everything in one location. The problem that I'm having is that we have set parameters for rural preservation. There are some exceptions or ways around that, if you will. But now to come and rezone this 10-acre plot, to me means that we're going outside of the box that the comp plan, planning commission, and board of supervisors set up years ago with certain goals in mind. So we're now with what I would consider a spot zoning. We're being asked to come back and chip away. Certainly, if the applicant was residing on the property, I think I would have be more receptive to it. The applicant, in his application, said he was about 1/8 of a mile from 3 other businesses. That being the Crab Shack, Pine View Grocery. I think there's a lumber yard. I don't know how long those businesses have been in operation, or whether they're under some other type of exception. And not being nitpicky, but he said it was approximately 1/8 of a mile. Well, that's 660 feet, give or take. when in actuality, it's about 3/10 of a mile. So if you're going to draw upon the close proximity to other businesses, please, let's get the measurements right. But overall, at this point, especially since it is not consistent with our comp plan, I'm having a bit of difficulty with it. I don't know how the rest of the board feels. I mean, this is
And Mr. Schwartz, I might add, I'm happy to go over some of the legal issues that you raised there, spot zoning, for example, and what that means, it doesn't mean. But you may want to hear, let the applicant do the applicant's presentation and then the public comment, and then I can address any legal issues that you want addressed.
Thank you.
Thank you. I think it's time that we should hear from the applicant at this
All
time.
right, yes.
Please, by all means. No, we're having the applicant. Please, by all means, give me your name.
Name's Mike Parker. I'm the owner of Quality Land Group and Quality Grounds. Quality Grounds has a long-term lease with Quality Land Group. Been in the county for 43 years. I've owned and operated Quality Grounds since 2001. In 2009, we purchased the old Luckstone facility on 301 that's in question today and began repairs there. In 2017, I hired a law firm, Richard Knapp and Associates, to apply for a zoning change. I paid close to $10,000 in fees. They did a minor subdivision. We did the soil work for the drain field on the piece of parcel there. And I was presented with a bill from the attorney saying it was all taken care of and our zoning was approved, which I didn't know any different. I had been operating down there mostly with contractor storage yard, like Craig said, storing our equipment and our materials, not really an office up until then. And then Craig let me know this year that, hey, there's a problem down there. We can't issue your business license to that address. I had applied to get the business license down there. So I went back to the law firm and said, hey, you know, I paid you close to $10,000 to handle this issue for me in 2017, and y'all assured me it was. They again assured me it was, but after checking with Craig and getting with Mike and Lisa, they had dropped the ball on it. So I'm here today to say, hey, we're a business. We employ 12 full-time employees in the county. Never been a day late on taxes. And this Luckstone plant, that's how it's listed in the tax map, has been taxed at a commercial rate since 2009. I understand it's zone rural preservation. So I went to the Mark Bassoon and say, hey, how can we be taxed at a commercial rate, which is higher than a rural preservation rate, and not be able to get the zoning we need? It was an answer he couldn't give me. He said it was a zoning question. So I'm here. I'm happy to answer any questions y'all may have.
Thank you. Do we want to open the public hearing, or you want to ask any questions?
I have a question. Sorry. Okay. Can you hear me?
Yes, ma'am.
Okay. I just want to make sure I'm hearing you right. So how long did you say you've had equipment stored there and been operating there?
We moved in
20
09. We probably didn't start putting anything down there until 2011, but all we did was store some sand, gravel, topsoil, mulch, that type of thing.
So where are the employees at? Are they there, or are they at your? Because the office right now is in your home, right?
We have a home permit, but since 2017, when the lawyers assured me that our zoning had been changed, I've had employees meeting there in the morning.
Okay, and you've been paying commercial rate taxes since
2009.
Hmm.
And I verified that with the Caroline office.
Okay. All right. I mean, question to staff, I mean, is that legal? That's what we can do?
Excuse me. So the tax is set by the Commissioner of Revenue's office, and they can, if they decide it's a commercial use, they can tax them for commercial even if the zoning isn't in place. such as if someone got a special exception on part of their property, they could tax them as a commercial rate for part of their property where the special exception is, and a regular residential rate on the other part of the property. The planning department does not get into that, and what you're being taxed doesn't necessarily have to coincide with the zoning, such as the special exception. So that's really a question for the Commissioner of Revenue.
Okay,
But he is correct that they have been charging commercial taxes on it since 2009. I did look at that.
okay. But legally, he's allowed to store his equipment, his business equipment there, correct?
Yes, that's correct.
Okay,
So this rezoning is mainly because he wants to fully operate out of this site.
okay,
So even though he doesn't live in this facility, he can still store his equipment at this location.
That's how it's been permitted in the past as a storage facility.
I have a question. You were assuming that all of your property was rezoned, is that correct?
No, sir. When we did the 2017, it was a minor subdivision, and we were only asking for those 10 acres. So I was told by the law firm, which I should have researched better than I didn't, that those 10 acres were approved, and that's all we're using on that site. It's the exact same area that Miller Smith Sand and Gravel used in the 60s, which sold it to Luckstone. It's the same area they used, and I'm just using the same area.
but this is not his business is not grandfathered because Luckstone was a different business, right? Operating before we had comprehensive plan. Is that what we're being told?
Yes. So yes. So when Millard Smith and Luckstone were there, it was prior to zoning in the county, and so there was no zoning. When zoning came into the county, you could apply to have your property rezoned to the appropriate zoning district, or you could keep the use that you had and not rezone it as a grandfathered use. So this parcel, they did not ask for a rezoning to change it to industrial for the sand and gravel operation in the 70s. And so once that operation ceased, then for 2 years, then it was RP. It's just RP property. And so Mr. Parker is not grandfathered, being that he started using it 2009.
Okay, I understand.
Any other questions from staff? The applicant?
Staff, so somehow, I don't know how to put it, somebody missed it.
Somebody messed up yourself.
I want to say it like
Say it,
that.
it's okay.
The-
I want to put it in
Priscilla.
a better
Yeah,
form.
the previous use of storing his equipment there was allowed as it was his property, and he's putting his equipment there. Now, in 2017, as Mr. Parker said, they did a minor subdivision on the site, and he had contracted the lawyer to do a rezoning, but the rezoning was never done. They did the minor subdivision to split off this 10 acres as a separate site from the overall land, and that's where it was left. And so Mr. Parker's trying to clean up what was the rezoning that he was supposed to come for in 2017, and it never happened.
And that occurred, Craig, in 2017?
This minor subdivision was done in 2017. Yes, that is correct.
So that's when this came to light?
No, when it came to light is when Mr. Parker applied for his business license this year to move his office from his home office to this site, and the appropriate zoning wasn't there for me to be able to sign off on the business license. And so I contacted Mr. Parker, told him that we would have to do a rezoning for this use because he didn't live there for the special exception, and so this is what Mr. Parker did.
Mr. Parker, how far do you live from this property that we're talking about?
Well, I didn't measure it, but I'm assuming about 5 miles. I live at the intersection of Mount Vernon Church Road and Reading Mill Road.
I see your address here.
Yeah,
Okay.
right there. It's called everybody knows it as Reading Mill Lake. That's where I live at.
All right, thank you.
Yep.
Any other questions for?
Mike, don't go too far in case I have some more questions for you.
will.
I know you will. Sure. I think we should open public hearing. That'd be correct. This time, I'd like to open the public hearing for RZ 02 2021 Quality Grounds. Anyone wish to speak at this time? Like to ask, public hearing for RZ 02 2021 Quality Grounds. Any public want to speak at this time? Last chance. I'd like to open the public hearing for RZ 02 2021 Quality Grounds. Anyone wish to speak? This time, I'll close the public hearing. Hey, gang.
Mr. Chairman, I'd like to ask Mr. McKenzie about the spot zoning issue and whether or not we could be leaving ourselves open for any trouble down the road if this goes for approval.
Sure. Thanks, Mr. Schwartz. Yeah, the issue of spot zoning, it comes up. It's relevant to any rezoning. I don't think this one's any different from any other rezoning. Spot zoning is, in reality, a fairly rare occurrence. What needs to happen for something to be spot zoning, which is not permissible, is that there is no benefit to the general public, to the county, to anybody else. The only benefits accrue to the property owner. And the important thing to bear in mind there, that, I don't know if any of you have done my planning commission class with Lou, but we go over this a lot. Of course the property owner is going to be benefited by rezoning. They wouldn't be asking for the rezoning if it didn't benefit them. The question that has to be asked to ensure that it's not spot zoning is, what are the other benefits? Does it benefit the county, or the general public, the health, safety, and welfare? Are there any other general benefits to this rezoning? And if there are, it's a really pretty low bar. Then it's not spot zoning. So you can look at the comp plan, you can look at the history of the parcel, the history of the use, you can look at public comment, you can look at any number of factors that are before you to see whether there are other benefits to this than solely for the property owner, who of course is generally going to be benefited by a rezoning application they make. So, in summary, Mr. Schwartz, spot zoning is in reality a fairly rare occurrence, and it's when something is rezoned and the benefits only accrue exclusively to the owner of the property. I hope that helps.
That did. Thank you, Mr. McKenzie.
Well, I think some of the issues that I have looking at this is the fact that Lux Stone was there, okay? It was an established facility. It was a working business one way or another. Whether or not it was in the comp plan or whatever, it was allowed at that particular time, okay, before the zoning came in. I'm just concerned that there is a piece of land there that was being used for a business facility. And by denying this application, if we assume that we would deny this application, what benefit is that going to do for that piece of land and as far as the county is concerned?
No.
None. Thank you. You answered my question. if it wasn't a facility already standing there that was being used as an industrial location, okay? Now we had Lux Stone there moving trucks in and out. Well, that's fine. They have a little office over there. I just think, we have to consider this very carefully, because I just do not want to see a piece of land that was used. And I don't know. I could probably ask Mr. Fincham or Craig, how many complaints did they have when Lux Stone was there? You can go through all that stuff. I just think at this particular stage, in my opinion, I don't think what they're asking for is an adverse condition to what already exists. That's my opinion.
And it's not, and we share the same opinion. I don't know if Mr. Parker intends to open up to public sales or not. If he does, that's another story. I wouldn't be opposed to that either. And certainly, if combining the two locations into one makes more business sense for him, I'm all for it. Absolutely. I just don't want us to get into a box that we stub our toe later on down the road with something else. I just want to try to avoid any of
And I appreciate that. The question I look at is, it's already an existing location. I don't think that Craig or Mike, if they had complaints, they would have told us, well, we have no complaints about it. When Luck Stone was there, it was an okay facility. So now this gentleman wants to come and he wants to park his trucks or whatever there, okay? I'm being very honest.
I think he already has some trucks. I think he already has. It's already in operation, but he just wants to move the main office there. So I mean, I can understand it. It's been operational for a long time. Although at the same time, we do have to be careful, like Mr. Schwartz said. For me, before us moving forward, though, I would like to know more about what the health department commented. They think the drain field should be inspected before moving an office there. And the drinking water, because, what we're now saying is the possibility the office could be there. So then so the only way we could do it is make it, what did we say, M1 industrial? Is that what we said, Mr. Pennington?
Yes, it would have to go to M1 industrial.
So, yeah.
It
is kind of a special situation. But if we're going to do that, we do have to, employees are going to be there. Drain field and the drinking water has to be inspected, in my opinion.
Right. If the rezoning were to get approved, then Mr. Parker would have to do a building permit for occupying the building as an office, and the health department comments would be taken care of on the building permit. And so that's how that would be handled.
So you're saying it's going to be done regardless?
Yes, when they apply for the building permit, the building department has to get verification from the health department that they can operate out of that office. And so the building department would not issue the permit if they couldn't meet the health department requirements.
Okay. So under agency comments, you're telling me that's going to be automatically taken care of?
That would be addressed at permitting, yes.
Okay.
Is it correct? He can't get a occupancy permit unless all that's taken care of. Is that correct?
That is correct.
Any other questions?
And so any comments from the Mattaponi Commissioner, because it's in your district, correct?
I'm okay with it, But like I say, we can't make,
So may we have a motion, please?
Mr. Chairman, I'd like to make a motion, please.
Please, sir.
Whereas rezoning request RZ 02-2021 for Quality Grounds, Quality Land Group appears to be generally consistent with the goals and objectives of the comprehensive plan and future land use map. And whereas the public necessity, convenience, general welfare, and good zoning practices warrants the approval of this request, I believe I'm going with the right one. I recommend that RZ 02-2021 be forwarded to the Board of Supervisors with a recommendation of approval.
Second. Heard a second?
Second.
All those in favor?
Aye.
Opposed? Hearing none, motion carries.
You too, Mr. Parker. Take care.
text amendment. All right, we got to text amendment, TXT 01-2021, subdivision ordinance, section 2, definitions. Staff, please.
Thank you, Mr. Chairman. Staff is presenting for public hearing TXT 01-2021 that modifies the definition of subdivision in Article 2 of the subdivision ordinance so that property acquired or created by the Board of Supervisors does not constitute a subdivision with regard to the future division of the property. This text amendment has been brought about by the county's efforts to secure land for a new fire station in the Sparta area. At the March 9th meeting, the Board of Supervisors referred the proposed amendments to the Planning Commission for consideration and recommendation to the Board. The amendment is as follows with the proposed modification in blue. Subdivision. A division, subdivision, or re-subdivision of a lot, tract, or parcel of land situated wholly or partly within the boundaries of the county into 2 or more lots, tracts, or parcels of land for the purpose, whether immediate or at some future time, of the transfer of ownership of any of these, or for the purpose of the erection of a building or other structure on any one of them. Any lot, tract, or parcel of land created and acquired by the Board of Supervisors, whether through condemnation or purchase agreement with the underlying property owner, shall not constitute a subdivision for purposes of this ordinance.
Questions from the board?
Good. Let me think about it. You got the public hearing.
Public hearing, so we go first. Then we ask the public.
Yeah. I might have questions though after.
Like to open public hearing for TXT 01-2021. Anyone in the public wish to speak? You come forward now. Anyone wish to speak on TXT 01-2021? Please step forward now. Last call. Any of the public wish to speak on TXT 01-2021? Please step forward now. He knew I was going to throw a hammer. Hearing none, public hearing is closed. Okay, Carol.
Okay, Mr. Pennington, we're adding the blue, right? You're not changing, you're adding.
That is correct. We're adding the blue. The way the ordinance reads right now is every parcel existing as of 1989 is allowed one subdivision of land to sell, anything like that, or family subdivisions. They're allowed more than one, sometimes depending on how much acreage it is, but it has to go to family members. So if a parcel of land was subdivided off of someone's parcel to then sell to the Board of Supervisors, then the way the ordinance reads right now, they would not be able to subdivide their land again. And so what this ordinance is doing is if the Board of Supervisors is trying to buy land from a landowner and subdivides that land off, that landowner would still have the right to subdivide their land one time in the future.
Understood. So we're passing on the allowability to subdivide it again at some particular time.
Correct.
Well, how many times are we saying they can subdivide their land?
They would be allowed one. They would be allowed the one subdivision that they are by the ordinance, and then the county could buy as many parcels as they wanted from them, and it not constitute a subdivision blocking them from doing further subdivision. And so it's basically saying if the county is buying your land and subdividing it off, then you retain the other subdivision rights that are already given to you in the ordinance. Whereas if this were denied, then that subdivision for the Board of Supervisors land would not allow any more subdivisions for that landowner.
It wouldn't penalize the landowner
Withheld.
for selling a parcel to the county.
That's what this ordinance does, yes.
Okay, all right, now I'm starting to get it. Did you have a comment, Mr. Finch?
No, that's fine. It was clarified.
I was kind of all over the place, sorry.
All right, can I hear a motion?
Well, it's a public necessary convenience, general welfare, and good zoning practice warrants and approval of TXT 01 2021. I recommend that the subdivision ordinance be forwarded to the board of supervisors for approval. Recommend approval.
For a second?
Second.
All in favor?
Aye.
Opposed? Hearing none, the motion carries. All right, I'd like to open the discussion on TXT 02 2021.
Thank you, Mr. Chairman. Staff is presenting for public hearing TXT 02 2021 that modifies Article 12, lot size and other dimensional requirements, Section 2, exemptions and reductions. This text amendment was precipitated by the county's efforts to secure land for a new fire station in the Sparta area. At the March 9th meeting, Board of Supervisors referred the proposed amendments to the Planning Commission for consideration and recommendation to the board. The amendment is as follows with the proposed modification in blue. Public facilities and public utilities of the governing body, as defined in Article 2, shall be exempted from the requirements of Article 12, Section 1, with the strike-throughs of the rest of the paragraph.
So Craig, this is basically being done for the same purpose as the previous amendment.
That is correct.
Can you define the governing body?
Caroline County Board of Supervisors.
Okay.
Or one of its authorized entities.
An authorized government.
Under the Board of Supervisors, under the auspices of the Board of Supervisors, yes. So it's not broadly interpreted. Mr. Chairman, members of the commission, let me give you probably a concrete example of the benefit of this ordinance amendment. And I'm going to refer to our utility system. If you're familiar with a public sewer system, you have a gravity system which everything flows downhill. But you also have force mains where you have a pump station that has to force that sewage uphill wherever you have a pipe installed that you've got to go up and over a contour to get to another gravity line. The way this current ordinance is written, if a pump station was located in the RP zoning district, your minimum lot size for a pump station that might be 20 by 20 would be 10 acres of land. And you would have to meet the setbacks for an RP zone 10-acre lot. So you have this huge 10-acre parcel with this small pump station located in the middle of that 10-acre parcel, which really makes no sense whatsoever. We've been fortunate that the majority of all of our facilities like that are located in the business, industrial, or planned development districts where you don't have a minimum lot size. But as our system expands, we could very well be faced with a situation just like this, where without this amendment, we would have to acquire potentially a 10-acre lot to meet the ordinance requirements.
This allows, Michael, excuse me, sorry, Mike. Sorry, Mr. Mitchell. So this allows the governing body to adjust some of these restrictions that might occur when it would not be necessary.
Correct. And for example, the reference to the potential fire station site, the county really does not need 10 acres for a fire station. So you want to only acquire that amount of land necessary to accommodate the actual use. So there's any one of a number of situations where this would be beneficial.
Thank you.
So you're kind of talking about, because I don't think I have a copy of Article 7, Section 1, but you're explaining to us, right?
Yes, Section 2.
I'm exempting them, if I vote yay, from the requirements of Article
Right, the minimum lot size.
12, excuse
Right,
me,
that's
not
right.
7.
The minimum lot
Section
size
1.
and setback.
Got my
requirements.
glasses on now. So- Yeah, but you see what I'm saying? I'm not looking at the article right now, so I'm trusting Mr. Fincham.
Actually, Article 12, Section 2 is that language at the bottom of the page.
That's it?
Yes, this is Article 12,
Section 1. Right.
Oh, Section 1 are your setback your lot area and your
Okay.
setback requirements.
All
Right. So that's where you have your 200-foot setback for a 10-acre lot, your 50-foot side and rear setback. So that's the provision where you have your lot size for the zoning district, as well as your setbacks for that lot size.
And that's what I thought you were talking
Yes,
about.
ma'am.
I just wanted to make sure.
I apologize if I confused you.
That's all right.
Ready to make a motion?
Oh, I have to open the public hearing, but there's nobody out there. Okay. No. I'll open the public hearing, sorry. I'd like to open the public hearing for TXT 02 2021. Anyone wish to speak on this matter? Anyone wish to speak on TXT 02 2021? Please step forward. Anyone wish to speak on TXT 02 2021? Please step forward. Hearing none, public hearing is closed. Now we'll take a motion.
All right. Whereas zoning request TXT 02 2021 appears to be general consistent with the goals and objectives of the comprehensive plan and future land use map. And whereas the public necessity convenes general welfare and good zoning practices warrants the approval of this request, I recommend that TXT 02 2021 be forwarded to the Board of Supervisors for the recommendation of approval.
Do we hear a second?
Second.
All in favor?
Aye.
Opposed? Hearing none. TXT 02 20 02 03 21 is
Thank you, Mr. Chairman. In April 2016, the Board of Supervisors adopted a new floodplain ordinance incorporating it into Chapter 45 of the Code of Caroline, thereby rendering Section 6 of the zoning ordinance void. As a matter of housekeeping and to avoid confusion, Section 6 should be repealed from the zoning ordinance.
So the only thing we're doing here is adjusting the existing definition.
No, we'd be repealing Section 6 from the zoning ordinance. The new floodplain ordinance that is contained in the county code will handle all floodplain issues in the county from from now on. And so Section 6 of Article 15 of the zoning ordinance is void. We can't operate out of there anymore. And so we're just asking to repeal all of Section 6, the floodplain ordinance, from the zoning ordinance.
So what is, in general, what does section 6 say?
It's the old floodplain ordinance that governed the floodplain issues in the county before 2016. Now it has no function.
The old Section 6 was the adopted floodplain ordinance for the county. So it designated your 100-year floodplains. It designated all the regulations therein related to development within the 100-year floodplain. Since that ordinance was adopted in the zoning ordinance, the Board of Supervisors has adopted a new floodplain ordinance and put it in Chapter 45 of the county code, which is the environmental chapter. Eventually, the Chesapeake Bay regulations, which are also included in the zoning ordinance, will be migrated over to Chapter 45 as well. So we'll be putting all of our environmental regulations under one section of the county code and then cross-reference that back to our other provisions of the zoning ordinance. So really what we have are duplicative set of regulations. We have the zoning ordinance, we have the county code, which is the more updated ordinance. So we're simply repealing the provisions in the zoning ordinance, which are no longer applicable because of Chapter 45.
Okay, got it.
We're eliminating 04. Please. Is that correct, Michael?
Pardon?
You're eliminating 04. Please.
Yes, we are eliminating these floodplain regulations entirely from the zoning ordinance.
Any questions for staff? Joe, any questions?
They might not like it.
Well, I'm gonna jump up and say something. I'm opening the public hearing for TXT 04 2021, TXT 05 2021, TXT 06 2021. Can I combine them, sir? Michael, can I combine all three of them together?
Right now there's only one text amendment on the table, 03.
You still need to finish action on the floodplain ordinance.
Okay, so basically, we have to go back to 03 first?
Yes.
Well, we haven't finished 03.
Yes. The others are not. The next three ordinance amendments are not related to the floodplain ordinance.
Okay, so I have to open the public hearing on TXT 03 2021. Does anyone out there wish to speak on TXT 03 2021? Anyone wish to speak on TXT 03 2021? Come on, guys, jump up and say something. Anyone wish to speak up on TXT 03 2021? Hearing none, public hearing is closed.
Mr. Chairman, I'd like to make a motion.
Please, sir.
Whereas the public necessity, convenience, general welfare, and good zoning practices warrants the approval of TXT 03 2021, I recommend that TXT 03 2021 be forwarded to the Board of Supervisors with a recommendation of approval.
Do I have a second? Hearing a second. All those in favor?
Aye.
Aye.
Opposed? Hearing none, motion carries. Now explain to me what we're doing with I could do all three of these at once? Thank you, sir. I appreciate that, especially since the audience is getting very restless out there. Okay. I'd like to. Okay. I'm gonna open up any comments on TXT 04 2021, TXT 05 2021, and TXT 06 2021.
All right,
And-
Mr. Chairman,
Please.
TXT 04-2021 is an ordinance to amend to amend the zoning ordinance of Caroline County by amending Article 2 definitions to repeal the current definition of car wash and replace it with a new definition of car wash. The purpose of the amendment is to qualify that a car wash is intended to provide services to motor vehicles with maximum registered gross weight of less than 7,500 pounds. And so this would exclude truck washes such as tractor trailers. It would just be car washes. And you can see the existing definition and the proposed definition at the bottom of your sheet. TXT 05 is to add car wash as a by right use to the B1 zoning district. And TXT 06 is an ordinance to add development standards for a car wash. And the development standards follow the text amendment on your page.
I just like to hear that music, the car wash, you know, that's, I mean, that's what I'm thinking. It's a good movie, too.
I have a motion to carry out, please. Now, some of the stuff that's here on the standards for the car wash, is this not standard production information, like, for instance, the oil and water separator and so forth and so on? Greg?
The oil water separator would be brought up by DEQ for the stormwater development of the site. If the site ended up being less than an acre, we wouldn't get DEQ comments, and so that standard is just to ensure that we're going to meet environmental matters.
Thank you. Any other questions from the board? So I can let this audience go. I'd like to open a public hearing on TXT 04 2021, TXT 05 2021, and TXT 06 2021. Public hearing is now open. Anyone wish to speak on this, please feel free to jump out of your seat, come up and talk to us. Come on, Michael. Is anyone out there wish to speak on TXT 04 2021, TXT 05 2021, and TXT 06 2021? Please stand at any time. Last call. Public hearing. Does anyone wish to speak on TXT 04 2021, TXT 05 2021, TXT 06 2021? Hearing no comments, public hearing is now closed. Somebody want to make a motion?
We have to do
What?
these separate.
Separate motions are required.
Whereas the public necessary, whereas the public necessary convenience, general welfare, and good zoning practice wants and approval of TXT 04 2021. I recommend that TXT 04 2021 be forwarded to the Board of Supervisors with recommend approval.
Second.
Aye.
All opposed?
None. Motion carries. I hear a motion on TXT 05-2021.
I'll make a motion.
Please, sir.
Whereas the rezoning request TXT 05-2021 appears to be general and consistent with the goals and objectives of the comprehensive plan and future land use map. Whereas the public necessity, convenience, general welfare, and good zoning practices warrants the approval of the request, I recommended that TXT 05-2021 be forwarded to the Board of Supervisors with recommendation of approval.
Second.
Have a second? All those in favor?
Aye.
Opposed?
Opposed? Hearing none. Motion carries. Last one, guys.
I can do the last
Go
one.
ahead.
These are text amendments, right?
That's correct.
Whereas public necessity, convenience, general welfare, and good zoning practice warrants the approval of text amendment 06-2021. I recommend that text amendment 06-2021 be forwarded to the Board of Supervisors with the recommendation of approval.
Second. All those in favor?
Aye.
Opposed? Hearing none. Motion carries. Mr. Fincher? Any and all matters, Mr. Fincher?
Mr. Chairman, members of the commission, the last item on the agenda tonight is a request to authorize to advertise for public hearing a proposed amendment to which would be TXT 07-2021, which we propose to amend Article 15, Section 15 of the zoning ordinance, which is the Highway Corridor Overlay District. The request would be to amend or extend the boundaries of two roads in the county. One would be to extend the boundary of Route 639, Ladysmith Road, and 738 Partlow Road from the current terminus, which is at the entrance to Lake Landor. This ordinance amendment was discussed with the supervisor for the Western Carolina District and is intended as a protective measure to tie into the solar ordinance amendments that the Planning Commission previously forwarded to the Board of Supervisors, and would provide some additional protection to that corridor related to the any potential solar facilities that might be relocated, that might want to locate in that area. We've got a number of small businesses in that area that the board has approved. We have a vineyard. We have a special events facility. We have the archery facility in Childsburg. And we want to make sure that we protect the businesses in that corridor from potential visual impacts from solar facilities that might want to locate that along that corridor. The second amendment would be to Route 606, which is Stonewall Jackson Road, would be to establish a highway corridor overlay district from the Spotsylvania County line to the intersection of Academy Hill Road. There has been some development interest in that area. You will be receiving a rezoning application in the not too distant future. And staff is working on a comprehensive plan amendment specific to that area. And in discussing the issues with the supervisor, we thought it was appropriate to bring an ordinance amendment for that section of road also. So the request would be to authorize a public hearing at your May 27th meeting on these amendments.
Can I ask how the highway, is it going to protect it the same way in both areas?
Yes.
Or is it two different?
It would be subject to, you would have the same standards There is a reference in the solar regulations to visual impacts to the Highway Corridor Overlay District. But in terms of, for example, access, landscaping improvements, those would all be common to both areas.
Okay.
So the intention here, Michael, is to bring this public hearing.
Yes, sir, at your May meeting would be the request.
I'm not against any of it. I just, not to be honest, Mike, I can't remember the West Lake Landor out to Partlow Road. I'm just trying to remember how far that is. So we were trying to protect that area.
It goes out to Childsburg, and it goes west of Childsburg to Spotsylvania County. Well, about 6 miles,
Oh, yes.
probably about 6 miles in length from its current terminus.
And the other you're talking about from, on 606, where did you say that's gonna be? From Guinea all the way to Spotsylvania line?
No, no, ma'am. It would be from
Edge Hill Academy Road?
Edge Hill Academy Road to the Spotsylvania County line.
Okay.
I have no reason to say we shouldn't bring this to public hearing. Any problem, gentlemen? Then we need a motion to bring this. to
Yes,
public
please.
hearing. Okay, can I have a motion, please?
Mr. Chairman, I make a motion, we authorize, for a public hearing for TXD 07-2021 for our next meeting on May 27th.
Second.
Oh, you want a second? I'll second it.
I second it.
Oh, that's what I thought. So
Okay.
now we got to vote, right?
All's in favor?
Aye.
Opposed? Hearing none, motion carries. That'll be good, Mike. We'll bring this on May 27th. Need a motion to adjourn, unless somebody else has something else they wish to speak.
A motion to adjourn?
Second.
All's in favor?
Aye.
Opposed? Hearing none. Motion carries. This meeting's adjourned. Thanks, guys. Just
Have a
wish-
good night, everyone.
I just wish this.
Night,
Thanks, Chris.
Mr. Fincham or Mr. Pennington, I just had a couple of questions. Okay.